Hello everyone, my name is Mark Astra and I am the founder of BakerActAttorneys.com. We're the only law firm in the entire state of Florida that does one thing and one thing only, which is the Baker Act. We help people from all over the state who are having issues with the Baker Act. Now, this document here, all 185 pages of it, that is the Baker Act. That is Chapter 394. And we get calls from people who are having all kinds of issues as a result of this statute. Now, we typically handle three different types of case. Most of the calls that we get are from families whose loved ones are stuck in facilities. They are there and they cannot get out and they call us for help. So the Baker Act, which is Florida's involuntary emergency stabilization statute, allows for a facility to hold somebody for up to 72 hours. Not for 72 hours, but up to 72 hours. But only if they meet criteria. And what does that mean? It means that people are being held illegally, people are having their statutory and constitutional rights violated, but the facilities don't care. And the reason for that is because nobody is watching them. There is zero oversight. So when your loved one gets taken to one of these facilities, they have, for all intents and purposes, fallen into a black hole. And there's only one way to get them out. And that is to go to court, to file a form of lawsuit asking a judge to order the facility to release them. And if you don't do that, the facility can and they will go to court themselves. And they will ask a judge to authorize the state to step into your shoes and basically give the state the authority to commit your loved one to a state mental health facility for up to 6 months. For up to 6 months. So this is really, really serious stuff. And worse yet, this stuff is all done in secret. I'm sure many of you have tried to call the facility and find out what's going on and been blanked or had your phone calls ignored. Okay, the Baker Act is done in secret. If there's a hearing, you probably won't even know about it until it's been done and your loved one is basically being sent off to a state mental health facility. So that's the first type of case that we handle. We also get calls from people who are out of a facility but they've been wrongfully Baker Acted. In other words, their rights were violated, they were held way beyond 72 hours, and then the facility at some point lets them go. And now they're out, and they are suffering from the physical and emotional stress that goes with a wrongful Baker Act. If you've been physically injured, and when I say that I mean bruises and broken bones, there is an opportunity potentially to file a claim for a wrongful Baker Act. But I will tell you, if you weren't injured, in other words, if you don't have any physical damages, there is no right under that statute I just showed you to get money. I know that sounds terrible. I wish it were otherwise. If it was, I'd have been retired a long time ago. But the Florida Baker Act statute does not allow for you to get money just because they violated your rights. That's why it's so important to act quickly and use that 72-hour window as an opportunity to get your loved one out before the facility tries to keep them. So those are the cases. One other case we get called about are people who have lost their right to own a firearm, and now their concealed right to own have a concealed weapons permit is gone. They can no longer get it. So the state has taken it, and the only way to get it back is to petition the state to give it back. And obviously, if you've been illegally Baker Acted, there may be grounds for doing that. The last type of case we typically handle is for people who are getting bills for services rendered. Can you imagine that? You have been taken to a Baker Act facility, you've been held against your will, you've been held illegally, your rights have been violated, and now the facility sends you a bill for thousands of dollars. They want your money. They want you to pay, even though you should never have been there in the first place. So we can help you with those cases, but you can't wait too long because what will happen is the facility is going to put you in collection and potentially ruin your credit. So those are the cases that we handle. Now, I love getting questions from people. If you go to our FAQ section on the website, you'll see I've answered a bunch of questions. And if you have any sort of questions about how this whole thing works, I invite you to go to that section of the website and see if I've already answered it. If I haven't, of course, we're happy to give you a free consultation. You call the number that's on the website. You can even email me, mark@bakeractattorneys.com. And actually, if you email me and ask me a question, I'll shoot a video and I'll answer it and I'll post it on the website. So I always invite questions and comments, and I'm happy to give you a free consult. With that said, thank you for coming to our website. I look forward to helping with you. And remember, the Baker Act statute is abused. You got to move quickly. Thank you very much. Take care.